Hi, thanks for using my court coach. I'm Sarah, and I'll be your instructor today as we talk about the joint petition for summary dissolution. In order to fill this out, one of you needs to fill in your information at the top. The court will give you a case number. This will be handed out when you go to file the court. List one of you as petitioner 1, one of you as petitioner 2, and then indicate if this is a joint petition for summary dissolution of marriage or domestic partnership. Below in line 2, you want to list your date of marriage or the date that you registered as domestic partners on. And then in line 3, you want to list your date of separation. There are some requirements in order to file for a summary dissolution, and we did go over that in the video that goes over summary dissolutions generally. But basically, this form is going to have you verify that all those qualifications that are necessary for summary dissolution do in fact exist. So, line 4, it states that less than 5 years have passed between the date of our marriage or registration of our domestic partnership and the date of separation. Again, a summary dissolution can only happen in a marriage that is 5 years or less. Line 5 has to do with the jurisdictional requirements. One of you has to have lived in California for at least 6 months prior and in the county of filing for at least 3 months prior to filing this petition. If you are asking to terminate a same-sex marriage but are not currently residents of California, that's okay as long as you were originally married in California. If that's your situation, then you want to mark box 5B. Line 6 indicates that there are no minor children who are born of this relationship before or during the marriage or domestic partnership. Line 7 states that neither of you has any interest in any real property anywhere. You may have a lease for residence so long as it terminates within a year of filing this date of petition and there's not an option to purchase. Line 8 indicates that the obligations incurred by either of you does not total more than $6,000, and that is excluding cars. Line 9 indicates that the total fair market value of your community property assets, and this is your net value, not including cars, is less than $45,000. Line 10 assures that neither of you have any separate property assets, again, not including cars, in excess of $45,000. Line 11 is part of your requirement to exchange your preliminary declarations of disclosure. So line 11 verifies that you have each filled out and given each other a copy of the income and expense declaration. That's your form FL800. Line 12 states we've complied with the preliminary disclosure requirements as follows. Either you have filled out and exchanged the worksheets that are on pages 7, 9, and 11 of the Summary Dissolution Information Booklet, Form FL810, or you have filled out and exchanged the Declaration of Disclosure forms, which consists of the Declaration of Disclosure, Form FL140, the Schedule of Assets and Debts, Form FL142, or the Property Declaration, Form FL160. 12B states that you have each told each other about any investments, business, or other income-producing opportunities that have come up after separation based on investments made or work done during the marriage or domestic partnership and before separation. Line 12C assures that the parties have exchanged tax returns that each of you have filed within the past 2 years. And then line 13 has to do with whether or not you currently have any community assets or liabilities. If you do not, you can mark box 13A. If you do, then you will also need to include an agreement that lists and divides those assets and liabilities, and include a copy of that to your judgment of dissolution or notice of entry of judgment form. And so if that is the scenario you fall under, you would want to mark box 13B. Line 14 indicates that irreconcilable differences have arisen between the two of you, and you're asking to dissolve the marriage or partnership. Line 15, if either party wishes to have their former name restored, you'd want to mark the box that correctly identifies which party that is and what they want the name to be restored to. Include the name in full, so first name, middle name, last name. Line 16 states that in filling out this joint petition for summary dissolution, you understand you're each giving up your rights to appeal and move for a new trial after the effective date of the judgment of dissolution. Line 17 indicates that you understand you both are forever giving up the right to ask for spousal or partner support from the other as a result of this judgment of dissolution. Line 18 indicates that you both agree that for the next 6 months from the filing of the petition, you will notify the other of any change of address, and there's a form that you can use to do that called a Notice of Change of Address form. That's Form MC-040. Line 19 indicates that along with this petition, you are submitting the original and 3 copies of the proposed judgment of dissolution and notice of entry of judgment form, as well as 2 stamped envelopes with the petition. One is addressed to each of the parties. Line 20 indicates that you are agreeing that the matter can be determined by a commissioner sitting as a temporary judge. And then in line 21, you're going to list the address for the first party. In line 22, you're going to list the address for the second party. There are a number of pages attached that we have referenced, so total those up, fill that in line 23, and then at the bottom, there's a space for each of you to include your signatures and date this form, and then you can take this to the courthouse along with your judgment of dissolution and notice of entry of judgment for filing and submission. I hope you found this helpful. Good luck.